Welcome to the Deep Dive, the shortcut to being truly well-informed, where we take complex, often dense source material and distill it into memorable, surprising nuggets of knowledge. Today, we are undertaking a really deep dive into what is perhaps the most defining legal showdown in the history of modern India. We're talking about a moment when, well, a 13-judge Supreme Court bench came together to answer a pretty fundamental question. Does a constitution have, like, an inviolable identity? Does it have a soul that even the strongest elected majority can't just tear down? We're, of course, talking about the landmark case of Kesavananda Bharati v. State of Kerala. The judgment came down in 1973. Our source material today really goes into the longest and you could argue the most consequential judicial hearing in, well, maybe all of South Asian history. And it was all sparked by a challenge from a single humble monk against the seemingly, unlimited power of Parliament.
Exactly. This deep dive is really about the ultimate boundary of state power. The core conflict, like you said, it just boils down to this tension. Constitutional supremacy versus parliamentary sovereignty. Who really has the final say over the fundamental nature of the nation? Is it the elected representatives, the ones with the mandate from the people to pass laws?
Or is it the founding document itself? The text that's supposed to retain its identity to protect the very rights and democracy it sets up?
Precisely. That's the heart of the matter.
Okay, let's unpack this. For you, the learner, getting into the details of Kesavananda Bharati is, well, it's much more than just a history lesson. It's really a master class in constitutional defense. It's the ultimate lesson in how modern democracies, especially those, forged in the Commonwealth tradition, arm themselves against that internal threat, the tyranny of the majority. This is truly a global lesson on constitutional resilience, and it was all defined by a single vote. To really get the drama and the stakes involved here, we have to set the scene. Early 1970s India, the country was standing at what our sources explicitly call a constitutional crossroads. And frankly, the path they seemed to be on looked, well, distinctly authoritarian.
It was an incredibly tense period. You have to remember, after the 1971 general election, the ruling party, led by the Prime Minister at the time, Indira Gandhi, had this massive, just unprecedented parliamentary majority.
Right, not just a simple majority.
No. This was a legislative powerhouse. And they felt they had an absolute mandate to push through sweeping reforms, even if those reforms meant fundamentally changing the constitutional architecture itself.
And here's the absolute core of the issue, isn't it? Parliament wasn't just using this huge majority to pass new laws.
Yeah.
They were using it to amend the Constitution itself, seemingly at will. And this went way beyond just procedural tweaks.
Oh, absolutely. The sources really highlight this. These amendments were often explicitly designed to overturn Supreme Court decisions that the government didn't agree with.
That cycle, that legislative override cycle, that's where the danger really lies, isn't it?
That's the existential threat right there. Let's make this specific, because it wasn't abstract. Back in 1967, the Supreme Court had made a really crucial ruling in a case called Golaknath. They basically declared that Parliament could not amend fundamental rights. That was a big check on power.
A line in the sand.
Exactly. But Parliament, which was determined to push through things like land reforms and nationalization, well, they responded swiftly. They passed a series of pretty aggressive amendments specifically designed to reverse that judicial restraint imposed by Golaknath.
So what were the actual legal mechanics? How did Parliament try to sort of gut the judiciary's power? Because the sources make it clear this wasn't just a political disagreement. It felt like a targeted legal maneuver.
Yeah, you have to look at the specific amendments passed around that time. Really crucial was the 24th Amendment Act of 1971. This amendment explicitly gave Parliament the power to amend any part of the Constitution, including the Fundamental Rights Chapter.
Oh, any part.
Any part. And it mandated that the president had to assent to any such amendment. So basically, it wiped away the restriction from the Golaknath case and aimed to establish Parliament's unlimited amending power. No ifs, ands, or buts.
They were trying to build a legislative superhighway, just bypass the courts entirely.
Pretty much. Then came the 25th Amendment Act, also in 1971. This one dealt with property rights and compensation. It allowed the government to acquire private property for public use and, critically, said the amount of compensation couldn't be questioned in court just because it wasn't adequate.
Shielding nationalization from review.
Exactly. It effectively insulated those major economic policies from judicial scrutiny. And then finally, the 29th Amendment Act in 1972. This was the direct trigger for the Kesavananda case itself. It put specific state land reform laws into a special schedule, the Ninth Schedule, which basically placed them beyond challenge in the courts on the grounds that they violated fundamental rights.
So let me get this straight. If the Supreme Court says, hey, government, that action is illegal because it violates the right to property,
Right.
Parliament just turns around and amends the Constitution to say, actually, that specific violation is perfectly legal, maybe even retroactively.
That's precisely the loop they were creating.
It makes the will of the elected majority always superior to the foundational law. It basically guts the whole idea of judicial review, doesn't it?
It absolutely does.
Yeah.
And if we connect this to the bigger picture, this is the very definition of the threat we're talking about, parliamentary absolutism. If a governing body, doesn't matter how strong its democratic mandate is, if it has unlimited power to amend the Constitution, well, then it has the power not just to change the rules of the game, but to destroy the entire rule book.
And this brings up that deeper sort of philosophical tension, right?
Yeah.
The argument for unlimited parliamentary power, which was the position of the 6 judges who later descended in Kesavananda, is basically that Parliament represents the sovereign will of the people. If the people elect representatives with a clear mandate for change, who is this unelected judiciary to stand in the way and say, nope, sorry, you can't do that?
And that's a powerful argument. It's
Yeah.
a legitimate democratic argument, you know? It formed the backbone of the government's case. Their position was rooted in that sort of British model. Parliament is supreme. They argued, look, if the Founding Fathers had wanted specific limits on the amendment power, they would have written them in explicitly, like maybe requiring a special referendum or a supermajority, something like that.
But they didn't.
They didn't. So the argument went, Parliament's power must be plenary, meaning full, absolute, unqualified.
But the danger, and the sources really stress this, is that if Parliament can amend anything, what stops them from amending the Constitution to, say, remove judicial review completely, or declare India is no longer a secular state, or abolish free and fair elections altogether? If that happens, there's nothing left to protect minority rights or the fundamental, architecture of the state.
And that's exactly why the proponents of limited amendment power argued for what's called the doctrine of implied limitations. They said, look, even without explicit words saying you can't touch this, the Constitution has an inherent structure, a basic identity, that implicitly limits the amending power.
So the power given is to maintain the Constitution, not dismantle it.
Exactly. The power granted in Article 368, the amendment article, is a power to sustain the Constitution, not a license to, dismantle the entire republic. And this case, Kesavananda, the sources make it crystal clear, this was the absolute last line of defense. It saved India's democracy from turning into parliamentary absolutism by finally defining that boundary.
Okay, so we've got this looming political threat, right? Unchecked legislative power really threatening the foundational contract of the nation. But often these big threats, they need an unlikely catalyst to really bring them out into the open. And in 1970s India, that catalyst came in the form, incredibly, of a humble monk.
Yeah, the irony here is just immense. It gives the whole case this profound, almost, mythological quality. His Holiness Kesavananda Bharati Supadagalvaru, the head of the Ednir Math, he was definitely not your typical constitutional crusader.
Yeah.
Our sources describe him as a humble monk from Kerala. He was the spiritual head of a relatively small Hindu monastery down in the Kasaragod district.
And his fight, initially anyway, wasn't about these grand philosophical ideas like separation of powers or even the 24th Amendment directly. It started, like so many crucial legal battles do, with something very local, very specific, a financial threat to his own institution.
Absolutely. The whole dispute originally stemmed from the Kerala Land Reforms Act. This was a specific state-level law aimed at regulating land ownership and tenancies. Its goal was basically to reduce the amount of land that could be owned by religious institutions and other private entities.
Okay, here's where it gets really interesting, as you mentioned earlier. That state land reform law, combined with that 29th Amendment we talked about, the one shielding such laws from judicial review, specifically sought to take over property belonging to his math, his monastery.
Right. And this property wasn't just, spare land. It was the economic lifeline for the monastery. It provided the income they needed to keep their religious and educational functions going. So the monk wasn't setting out to overthrow the state or anything. He was fighting to protect the survival, the religious and cultural continuity of his centuries-old institution.
But, and this is the crucial leap, to protect that land, his legal team, and they were headed by the absolutely formidable Madhaboy Palkavala, They had to argue that Parliament itself was exceeding its constitutional limits.
They did. They masterfully elevated what started as a localized property rights dispute into the most profound, abstract, and frankly, comprehensive question about the structure of the Indian state. Can Parliament actually change the fundamental identity of India?
That pivot from defending private property to defending public identity, that's just breathtaking legal strategy, isn't it? They saw that defending the monastery's land required defending the Constitution itself.
Absolutely. And the Supreme Court, to its credit, immediately understood the sheer magnitude of what was being placed before them. They realized they were staring down the barrel of potential parliamentary absolutism and the scale of their judicial response. Well, it tells you everything about how high they thought the stakes were.
Yeah, emphasized the sheer logistical challenge and the gravity of this. It wasn't just another case.
No way. The sources really hammer home the monumental nature of the hearing that followed. For starters, it became the longest and arguably still the most consequential hearing in India's judicial history, certainly up to that point. It was argued over an astonishing 68 days.
68 days.
68 days? Just imagine the intellectual and physical stamina required, not just from the lawyers, but from the judges themselves. Sitting there, absorbing, synthesizing arguments on deep constitutional theory for over 3 months solid. It just underscores the immense gravity of the matter.
68 days of continuous legal argument, basically trying to define the absolute limits of government power. That is a marathon. And to handle that immense weight, the court had to put together the largest panel it had ever assembled.
Correct. They convened a massive bench of 13 judges. Now, gathering such a large, odd-numbered panel, which is an implicit move to ensure there is a clear majority decision, no ties allowed, that alone shows the court knew the stakes were utterly existential.
They knew this was it.
They absolutely knew. They realized this verdict would be the definitive ruling on whether the Indian Constitution was truly supreme, or if it was just, a political document that could be reshaped by the whims of whoever had the most votes in Parliament that year. Every single one of those 13 judges must have been acutely aware that they were about to deliver a verdict that would either solidify India's status as a limited functioning democracy or potentially open the door for its ultimate constitutional erosion. The pressure must have just been unbearable.
So after those 68 grueling days of arguments, the entire nation basically held its breath. The tension, you can only imagine, was palpable. The judgment was finally delivered on a very specific date, one that's now etched into Indian legal history. April 24th, 1973. And the result, as the sources highlight, was pure high trauma, defined by the absolute narrowest possible margin.
It was incredibly close, a razor-thin decision. Those 13 judges, tasked with deciding the very future of the nation's constitutional framework, came down to a 7-6 split.
A single vote, just one judge's opinion, tipped the scales. The entire political fate of the Republic, the success or failure of the whole constitutional project they had started back in 1950, decided by one person. We really have to pause and just reflect on the absolute singularity of that moment.
And that crucial single vote belonged to Justice H.R. Khanna. His opinion was absolutely pivotal. He sort of bridged the gap between the judges who wanted to strike down those constitutional amendments entirely and those who believed in absolute, unlimited parliamentary power. Khanna essentially articulated the middle ground, the reasoning that became the heart of the basic structure doctrine. His ruling secured that foundational principle. Parliament can amend, yes, but it cannot cross the line into destruction.
So the core ruling itself was definitive. The Supreme Court established that while Parliament did have wide powers to amend the Constitution, it is, after all, supposed to be a living document that can adapt over time. It could not alter its basic structure.
And that's the genius of it, really. They didn't strip Parliament of its power to enact change, which is obviously vital for progress and responding to new challenges, but they placed this impassable, judicially defined boundary around the Constitution's core identity.
Let's get into the philosophical underpinning then, the ratio decidendi, the reasoning. The majority's logic was rooted in two really clear, quite elegant principles. The first one is the most famous. The power to amend does not mean the power to destroy.
That phrase, it's just a masterpiece of constitutional thinking, isn't it? It implies that power, even when it's legally granted, carries this inherent limitation that comes from the purpose of the document itself. It's like saying, okay, you have the delegated authority to renovate the house. You can move walls, maybe change the roof tiles.
Sure.
But that authority doesn't extend to demolishing the foundation and starting over with a completely new building that bears zero resemblance to the original structure.
Right. And the second principle follows directly from that analogy. Parliament's supremacy ends where the Constitution's identity begins. That identity, that core, is the basic structure. And the judiciary, acting as the custodian of the Constitution, reserves the right to define and protect that core.
So the ruling then had to give some idea of what those inviolable features actually were, what truly makes up this bedrock. Now, the court was very careful. They explicitly refused to create an exhaustive final list. They said the nature of the basic structure would kind of be revealed on a case-by-case basis as future challenges arose.
Okay.
But the majority judgment did identify several features they considered essential to the republic.
Our sources pull out 4 fundamental features deemed inviolable that really form the heart of this new doctrine. Let's maybe spend a moment on each, defining why these particular ones are so crucial.
Okay, sounds good. First, and maybe most obviously, democracy. And this isn't just about, holding elections periodically. It's the fundamental commitment to a representative, competitive political system based on universal adult suffrage. The idea is if Parliament could amend the Constitution to, say, get rid of free elections or make parliamentary seats permanent, well, they'd destroy the entire democratic basis of the state.
Makes sense. Second, the rule of law. This basically ensures that everyone, including the government, the executive, the legislature themselves, is subject to and accountable under the law, not above it. If you remove the rule of law, the government can just act arbitrarily, and citizens have no real recourse.
Third, separation of powers. This is that crucial architectural safeguard keeping the judiciary, the executive, and the legislature distinct, functional, and importantly, balanced. It's specifically designed to prevent too much power concentrating in any single branch. If Parliament could just declare itself the supreme interpreter of its own laws, for instance, that separation completely collapses.
And fourth, judicial review. This is the very power the government was trying to override with those amendments we discussed. Judicial review is the court's authority to examine the actions of the other branch's laws passed by Parliament, orders from the executive, and determine if they are constitutional. It's the mechanism that actually makes the basic structure doctrine enforceable. Without it, the doctrine is just a nice philosophical idea, easily ignored.
What's really fascinating here, though, is how interconnected these all are. Why these specific 4 elements as the bedrock? Well, they are the features that ensure the document remains a living constitution, one that actually protects citizens and limits the state, rather than just being a malleable political tool that changes with the wind. Think about it. If you remove judicial review, the rule of law basically collapses because there's no mechanism to enforce the limits.
Right.
If the rule of law collapses, democracy becomes pretty meaningless because fundamental rights aren't protected anymore. They really are the essential structural girders holding up the entire republic.
But hang on, doesn't defining this basic structure a concept that, let's be honest, isn't explicitly written down in the original 1950 text, doesn't that effectively turn the Supreme Court into a kind of third legislative chamber? Aren't they just overriding the democratic will of the Parliament?
No.
That was the core argument of those 6 dissenting judges, wasn't it?
It absolutely was, and that is the perennial tension here. The sources definitely reflect this criticism. The judiciary's justification, essentially, is one of necessity. They argue, look, we're not legislating here, we're merely interpreting the intent of the framers. Their argument is that the framers clearly intended to create a limited democratic republic, not an unlimited legislative sovereign like in the UK.
So they see themselves as guardians.
Exactly. They position themselves as the guardians of the document's established identity, ensuring that a temporary majority doesn't accidentally or deliberately destroy the permanent framework that was established for all time.
It feels like a pragmatic recognition that giving Parliament unlimited amending power is like building a self-destruct button into your democracy.
Precisely. And if there's one single quote that really defines this monumental decision, that perfectly articulates this principle of implied limitation, it has to be the words of Chief Justice S.M. Sikri, who was the voice of that narrow 7-6 majority. He stated it very clearly. The basic structure is the foundation, the soul of the Constitution, and it cannot be destroyed even by constitutional amendment. That single word, soul, it just carries the entire weight of the judgment. It defines the Constitution not just as a technical legal document, but as something with a spiritual and philosophical core.
The soul. That's what they managed to protect by just one terrifyingly close vote. Okay, so the moment the basic structure doctrine was announced on April 24, 1973, the political landscape just shifted instantly. The political establishment, especially the ruling party with its huge majority, saw its power, its perceived mandate to change the Constitution, however it saw fit, suddenly curtailed. This wasn't just some abstract legal judgment. It felt like a constitutional counter-revolution delivered by the judiciary.
It was an immediate, powerful check on power. The ultimate achievement of Kesavananda Bharati was precisely the creation of this guardian doctrine for interpreting the Constitution. It immediately slammed the brakes on that cycle of constitutional chaos and legislative overrides that we talked about earlier.
It literally prevented the nation from sliding irrevocably into that state of parliamentary absolutism, which seemed, well, pretty imminent just before the ruling. The sources really highlight that the doctrine ensured that no matter how large a majority a ruling party might get in the future, they were always going to be subservient to the fundamental, unchanging identity of the republic.
And if you look at the subsequent political history of India, it really confirms how necessary this doctrine was. Just 2 years later, you had the period of the emergency from 1975 to 1977. During that time, the government attempted several measures aimed at dismantling democratic safeguards, including suspending fundamental rights entirely.
Right, a very dark period.
A very dark period, and it was the basic structure doctrine that provided the crucial legal foundation for subsequent courts to eventually push back and reverse many of those authoritarian measures after the emergency ended. It was arguably the doctrine that stopped the entire system from completely collapsing under that pressure.
And this brings us back to that overarching lesson, the sort of moral of the story that our sources present. Even the makers of the law must bow before the spirit of the law. It's such a profound recognition that the spirit, the core identity, it actually transcends the temporary individuals or parties holding political power at any given moment.
But what's also remarkable is that the doctrine's influence didn't just stop at India's borders. And this raises a really interesting question. How does a ruling that was born out of a property dispute involving a monastery in Kerala become this essential tool for constitutional protection across an entire vast geopolitical region?
Yeah, how did that happen? Because the sources confirm it spread surprisingly quickly. It influenced courts in several neighboring nations. Pakistan, Bangladesh, Nepal, and Sri Lanka specifically are mentioned. It became a vital tool in their own constitutional battles against authoritarian tendencies or executive overreach.
Well, take Pakistan, for example. There have been several instances where military regimes or dominant executives attempted to radically alter the constitution to consolidate their own power. And in those moments, Pakistani courts explicitly cited the basic structure concept, drawing on the Indian precedent.
Really?
Yes. They used the idea that even constitutional amendments passed during periods of military rule couldn't abolish core democratic or federal features of their own constitution. It essentially provided the judicial language, the necessary vocabulary, for them to try and preserve the fundamental contract between the state and its citizens, even under duress.
And what about places like Bangladesh and Nepal? They've also had significant political upheaval.
Absolutely. In both Bangladesh and Nepal, which have gone through periods of deep political turmoil and constitutional rewriting, the doctrine has been invoked. It's been used to defend foundational concepts like secularism in the case of Bangladesh or multi-party democracy in Nepal when those principles came under threat from political forces trying to change the state's identity.
So the doctrine essentially gave courts across South Asia this pre-packaged, legally sound framework to say, hold on a minute. There's an implied limit to your power, Mr. President, or Mr. Prime Minister, or Mr. General, and we, the judiciary, are the custodians of that limit.
Precisely. It managed to transform a single specific legal defense strategy from one case in India into a universally applicable theory of constitutional endurance, a theory relevant to millions upon millions of people across multiple independent nations, all facing very similar political pressures, namely that ever-present risk of strong executives or dominant legislative majorities trying to consume the entire state apparatus. That's the incredible, enduring legacy of that 7-6 split.
It's just a really powerful illustration, isn't it, that sometimes the most abstract-seeming legal theory can have the most dramatic, concrete, real-world consequences. It acted as a genuine shield for democracy in practice. #outro. So we've journeyed today through that intense constitutional crossroads of the early 1970s in India. We've detailed the incredible 68 days of argument, and we've witnessed the sheer drama of that 7-6 split that ultimately birthed the basic structure doctrine. This doctrine, well, it codified the really profound idea that a constitution actually has a soul. It has these inviolable features, things like democracy, the rule of law, separation of powers, and judicial review, which simply cannot be destroyed, not even by the very bodies, the parliament, that the Constitution itself creates.
And the result, as we've discussed, was the establishment of this incredibly powerful guardian doctrine. It halted that potential slide towards parliamentary absolutism in India, and it ensured going forward that elected majorities must always serve the Constitution rather than the other way around. It really redefined the balance of power in the world's largest democracy, and then, remarkably, became a vital precedent for millions across the entire region.
So what does this all mean for you, the learner?
Well, I think it means that even in the most chaotic political environments, even when things look dire, the text of a founding document can, with the intervention of a courageous and independent judiciary, create limits on power that are absolute. It demonstrates the ultimate check and balance against the sometimes fleeting, temporary will of a majority. And that protection is so critical, especially when you stop and think about the fact that the basic structure itself, those core features, they aren't explicitly listed out in some neat section of the Indian Constitution. Those 13 judges, under immense political pressure, they essentially had to discover those limits through deep philosophical and legal interpretation, rather than just reading them off a page somewhere.
Which I suppose leaves us with this final provocative thought to maybe chew on. If the basic structure cannot be explicitly defined in advance by the people who originally wrote the document, but instead it's sort of revealed by the judiciary only during these moments of crisis, does that mean the Constitution's true identity is always, in a sense, being discovered? That it's never fully written down? Is the soul of the nation only truly revealed and defined when its very existence comes under direct existential threat?